Now, to grasp the concept of living trusts, it's essential to comprehend the lifespan of an asset. Essentially, since we can't take things with us, the items we accumulate, be it in our name, housed in safety deposit boxes, or within our residences, pose an intriguing question. Whether it's cars, checking accounts, or other possessions, if they remain in our name post our existence, who inherits them? This leads us to the core issue. How do entities like the DMV decide the rightful owner of these assets? In the course of our lives, the manner in which we hold assets matters. A joint account, for instance, establishes rights of survivorship. It implies that if something happens to one owner, the asset automatically transfers to the other. But here's the twist. What occurs when the joint owner also passes away? This is a universal concern. Every estate contends with the fate of assets after one's demise. For smaller asset values, you might avoid an extensive legal process. Termed as low asset probate, it allows you to handle matters without an elaborate courthouse procedure. However, with significant assets like real estate, bank accounts, and stocks, the process becomes more complex. Let me simplify it by presenting the three distinct ways these scenarios are typically addressed. 1. Intestate, no last testament. The first scenario is what's known as intestate, where no specific arrangements were made. No will, no joint tenancy, and potentially complications arising from the passing of a joint tenant. Consider a couple owning a car, with the husband passing away first. The wife inherits, but upon her demise, chaos ensues without a will. Think of high-profile cases like Aretha Franklin or Pablo Picasso, where individuals passed away without clear directives. In the absence of a will, the process dives into probate, governed by state statutes of the location where assets were held or where the deceased resided. Here's where it gets intricate, especially if there's real estate spanning multiple states. Probate proceedings must be initiated in each state involved, extending the legal ordeal. Drawing from personal experience within my family, I can attest to the complexity. This legal process, averaging around 18 months in the United States, a figure potentially exacerbated post-pandemic, consumes about 20% of the estate's asset value per AARP estimates. Initiating this probate proceeding involves court interventions. Courts establish a timeline, notifying creditors and potential beneficiaries to make claims and express their interests. This prompts conflicts and legal battles, with lawyers benefiting from these courtroom scenarios. The court scrutinizes claims, determining the legitimacy and interests involved. Going through this legal ordeal means attending court hearings, and in some states, the process requires 2 appearances, opening and closing the probate. It's undoubtedly a cumbersome process. In the intestate scenario, the state mandates the proceedings, asserting its procedures. What's noteworthy is that even after this extensive process, there's no guaranteed possession of the asset. The state might exercise escheatment, claiming the asset if no one steps forward, channeling it into the general fund. Retrieving such assets becomes an arduous task, as the state firmly holds its claim, emphasizing the importance of adhering to probate procedures. 2. Testate. There's a will. The second scenario is termed testate, which essentially means you had a will. Even with a will in place, the state still invokes its authority, scrutinizing the will against state statutes and initiating a probate process. However, the fundamental distinction lies in the fact that, unlike intestate scenarios, the court isn't determining the beneficiary. It's ensuring that you followed proper procedures. So the court engages in an evaluation. It checks the legitimacy of the will. Were there witnesses? Did you adhere to all relevant state statutes? If everything aligns, you're granted the right to change the title and transfer the assets. The process involves notifying creditors, informing potential beneficiaries, establishing a timeline, and opening probate. But the proceedings are expedited because the court already knows the intended recipient. Despite having a will, you're not exempt from the legal hoops. The court process is inevitable. In the testate scenario, you get to make the decisions through your will, specifying how you want your assets distributed. While you're steering the course, the court ensures adherence to legal formalities. The probate period is shorter compared to intestate cases, primarily because the court is not engaged in the intricate process of determining rightful beneficiaries. It's more about validating your expressed wishes. 3. Living trust. Now let's explore the third option, the living trust. A living trust operates as a confidential agreement where I place my assets into a separate entity, holding the title independently. As the trustee, I wield control, utilization, and enjoyment throughout my life. Upon my passing, the trust seamlessly transfers to the next designated individual. While I may cease to exist, the trust endures, retaining ownership of the assets. A successor trustee appointed by me steps in and adheres to the trust's stipulations. Importantly, this process involves no court proceedings or oversight, given its nature as a private contract. When I transfer assets into the trust, I retain control and usage. Whether selling my house or car, I maintain authority over these assets, but the title resides in the trust's name, which persists beyond my death. Living trusts find extensive use for primary residences, other real estate holdings, bank accounts, stocks, bonds, diverse investments, and even interests in LLCs. This strategic use ensures a smooth transition of title without the need for court involvement or proceedings. This tool proves highly effective, though it's not universally applicable. Suited for many individuals, particularly those with families, children, and assets, a living trust offers a streamlined approach to ensure assets pass to heirs without the complexities of court procedures. However, it's essential to supplement it with a pour-over will. This safeguards against potential assets omitted from the trust, directing them to pour over into the trust and bypass probate. In essence, it's a preventive measure, steering clear of a separate probate proceeding. In summary, 3 pathways exist. Intestate, meaning no will. Testate, indicating a will with subsequent probate. And the living trust, a probate-free method, facilitating the straightforward transfer of title from the deceased person to the living heir. The living trust emerges as an advantageous tool, especially recommended for most clients, given its private, cost-effective, and hassle-free nature compared to the public, expensive, and cumbersome probate process. If you enjoyed this video, be sure to like and share it, and make sure to subscribe to our channel so you never miss any of our content. Also, don't forget to click the notification bell so you're alerted every time we drop new videos.